SJC-11956, Commonwealth v. Jimmy Warren.
What is this? Morning. Before we start, Mr. Lovins, I gather we've let you down, that our assistive listening device does not work this morning. So what we will do is we will all lift our voices, and I will ask you that if you have any difficulty hearing us, you just raise one finger in the air, and that will be the signal to us that we should speak more loudly, okay?
Thank you very much. And by the way, it's not the first time in my life.
That you've been let down? Okay. Well, we try not to, though. We try not
Join the
to,
club.
and I apologize for that, but we will adapt. We'll just keep our voices up, and again, if you would just lift a finger in the air to tell us you have any difficulty hearing, and then we'll lift our voices even more, okay?
I will. Thank you so much.
Yes, sir.
May I begin?
Yes, please.
Okay. Good morning. My name is Nelson Lovins. I represent the defendant, Jimmy Warren. The issue, I believe, before this court here today is whether there was reasonable suspicion of a crime having been committed, being in the process of commission, or about to be committed, existed prior to the command given to Mr. Warren to stop.
Mr. Lovins,
Justice,
can I just ask you this question? With respect to Judge Lyon's findings, or your own view, when do you say, put the first officer to one side? So I'm just focusing on the two officers who ultimately ran after your client. When do you say the stop occurred? When they got out of the car, or when actually, I think the officer whose name begins with C said stop? Is that the point?
no, as a matter of fact, my position, although Justice Agnes takes the position, he assumes that the seizure occurs at the command stop, the stop command, and I think that's Justice Green's position as well. But my position actually is that when Officer Carr got out of his car, and was within 15 yards, and he had the other officer with him, Santuoso, and he was within 15 yards of the defendant, and he said, "Hey, fellas, my position is that under the Barros case, that suffices for a seizure." Now, I understand that there are a lot of cases out there where the courts have said that that kind of language is nothing more than a request to be able to speak. I think what separates Barros and the Warren case from those cases is that in Barros, the officer made a request, then he drove up alongside of the defendant, get out of the car along with two other officers, one or two other officers, pointed at the defendant and said something like, "Hey, you, come over here, I want to talk to you." I think that the presence of the additional officer and the proximity of the police officer to the defendant was a sufficient show of authority for that to be considered a seizure. If it wasn't a seizure, then the stop command that was issued as Mr. Warren was running up the hill certainly is a seizure, and then the question becomes whether there was reasonable doubt prior to that. Now, I am mindful of the fact that the Commonwealth has put forward an argument which, at least in my opinion, is somewhat tortured about the finding that the trial judge made. But it's fairly clear that that view was rejected by Justice Green and Justice Agnes. Interestingly enough, Justice Rubin took the position that the seizure actually occurred before the stop command.
Way back. I mean, wasn't it with the first officer? Isn't that what he said?
Yes, that is correct. That was his position, and I think that is definitely arguable under Barrows. I am not conceding that the stop occurred as late as the stop command.
All right, is everyone in agreement? I doubt they are, but is everyone in agreement that the evidence was, and the judge found, that the officers did not see your client clutching his waist until after the stop command?
I believe that is correct.
Well, the Commonwealth argues that's clearly erroneous, right?
That is what the Commonwealth argues. The Commonwealth argues that there was some kind of a misunderstanding or a typographical error, and that's what I referred to before by a tortured argument. And it clearly rejected by Justice Green and Justice Agnes.
The trial judge.
And the trial
And the
judge,
motion
yeah.
judge.
Yes.
She rejected it as well. She made
Yes.
a specific finding on the point.
Yes, I believe so. Yes. So, if the seizure occurred when Carr said to the suspects, "Hey, fellas," there's even less basis for an argument for reasonable suspicion than there would be if it went on a few more minutes as he's running up the hill, because then you only have the addition of evasive action. So in other words, the difference in the reasonable suspicion continuum between the point in time where he said, "Hey, fellas," and the point in time where he issued the stop command was the evasive action. And we know under Stout, Thibault, and their progeny, and Mercado, that evasive action cannot be looked at for the purpose of determining.
Does it make a difference that you had your client running twice? In other words, he ran in response to the first officer's inquiry, and then he ran again with respect to officers Carr and Santos-Wasor.
Yeah, that's an interesting question, and I actually have thought about that. And I think that the answer is very clearly no. The reason is because I think the question here is reasonable suspicion as to whether it was Carr who had reasonable suspicion. Because if you go back and you look at the facts, you're going to find that Anjos, in his radio dispatch, never even said, "I asked these guys to stop." All he really said was, "These guys with this description are in the park." That's all he said.
He did. I thought he had said something. He didn't.
I don't believe he did. I went back and looked. In fact, I looked rather late last night, and I might have been sleepy. I don't know, but I couldn't find that. But I think what it comes down to is reasonable suspicion based upon what Carr saw. And of course, we all know it's got to be objective and not subjective.
Yeah. What about Anjos, Officer Anjos? Why didn't he have reasonable suspicion where he had investigated the breaking and entering, or the burglary, that he was told that there were 3 people that were at the scene, and they fled in different directions, and then he sees 2 men generally matching the description of 2 of the people that were seen at the site of the burglary, and at a location in which, in the direction at which at least some of those 3 people had fled, and at a location that would have taken approximately the same amount of time. And there was nobody else, to get to that location from the house where the burglary took place. And it was a cold night, and he hadn't seen anybody else out on the street. Why isn't that enough to stop?
Thank you for asking that question. First of all, if you go back and you look at the facts, the radio dispatch was to the effect that the suspects could have gone in one of two different directions. So it is absolutely not clear as to what direction these three suspects took. That's number one. Number two is that there were three suspects and not two. One of them was wearing a red hoodie. They had a backpack, and when Angelos came upon them, none of the three had a red hoodie, and none of them was wearing a...
It was only two, it wasn't three. It wasn't three.
I'm sorry, neither of the two were wearing a backpack. In addition to that, there was nothing about height, weight, appearance, facial hair, nothing other than that they were young black men, two of whom were in dark clothing, one of whom was in a red hoodie.
I think those are good points, but here we have nobody else out on the street. And why isn't the general description enough under those circumstances?
Well, it's a generalized description that at least Judge Agnes didn't think was enough, and of course I agree with that position.
Wouldn't you say, I mean, doesn't it make a difference that we're talking about Roxbury in Boston? We're not talking about West Tisbury
Yes, thank you.
on the Vineyard.
That's correct. And obviously, the population in Roxbury
I was really
is...
making the point that it's a city. I mean, there's a lot of people in a city, so it's not so surprising that you're going to see two different people on the street.
I think that's correct. So Judge Botsford has just made my argument, Judge Spina.
Going back to going back to the issue of when the stop occurred, in order for us to say that the judge was not clearly erroneous in finding that the officer Carr did not see him holding his waist until after he had yelled stop, do we have to believe that the judge did not credit the police officer's claim that he saw them as they were climbing the hill and yelled stop as they were climbing the hill?
No, I think what she found was that he did see him running up the hill, and he did see him clutching his pants. She also reported, because the testimony was such, that he knew of situations, he had seen situations where defendants were running and clutching their pants, and there was no firearm. But she did find that, and this really, I think, is the critical issue. She found that the command to stop was prior to the observation of Warren clutching his pants. She did make that finding.
She said that Officer Carr stated he made several verbal
I'm
commands.
sorry.
She said he made several verbal commands, not just one. Justice...
Yes,
Judge-
no, I agree with that, but I think we have to go with the first one. And based upon my reading, my interpretation of the record, and what Justice Green wrote in footnote 7 of his decision, it's my understanding that the first of those stops came before the clutching of the pants.
Yes, I said that Judge Lyons found that Officer Carr, I'm reading, Officer Carr stated he made several verbal commands for the defendant to stop and show his hands. And it was after that that he saw the clutching of the pants.
Yes,
So it was after several verbal commands.
I see what you're saying. Thank you.
Yeah.
So does the record, Mr. Lovins, does the record establish whether or not these two people or this one person, Mr. Warren, was dressed in the familiar attire, baggy
missed that,
pants?
please. I'm sorry.
Was Mr. Warren wearing baggy pants?
Yes, I believe he was.
That's in the record?
Yes, I believe he was.
Okay.
Yes, I believe it is. And also that apparently and this is in the record, apparently there was testimony that baggy pants is common type clothing that young black men wear, and especially in the winter, they're wearing hoodies.
Okay, thank you.
Thank you.
Good morning, Mr. Glennon.
Good morning. Michael Glennon for the Commonwealth. May it please the court, at the time of the stop in this case, the officers had essentially 7 different factors that lent themselves to their reasonable suspicion determination. Each and every one of those factors is important. And of course, taken together, which is how they should be, they overwhelm the reasonable suspicion determination.
And where do you, when you say at the time of the stop, what are you identifying as the stop?
So the trial court judge finds the stop actually in the backyard of 18 Wakulla Street. I'm willing to even back it up to the time that the officer is pursuing and yells the command to stop, which is shortly after the beginning of the pursuit.
And we're talking about Officer Carr now, or?
Officer Carr.
Okay.
When he gives the actual command to stop while he's pursuing the defendant through the park. But up until that point, we have a number of different factors. The first one being that this is a description given by a known reliable witness that was a face-to-face interaction with Officer Carr. And that description was of 3 individuals, 2 outside in dark clothing, 1 wearing a hoodie. And there was another individual in a red hoodie who was in the house. So I think it's important to note here that we essentially have 2 different units operating for this breaking and entering. We have the group outside that's
Well,
possibly-
didn't the person in the red hoodie jump out the window and go off with the other 2?
That's correct. That's correct, but I don't think it's unreasonable to assume that they're working together in conjunction with the red hoodie, but that if they happen to split up along the way, because the guy in the red hoodie is the one who's in the house, he's the one who took the items that were taken during the B&E. So we have 2 people, dark clothing, 1 in a dark hoodie. I think it's important to understand here that while these descriptions are general, they become exponentially more specific when you're talking about 2 people versus 1 person. An individual in that city, in that area of the city, according to the officer's testimony, in dark clothing, not unusual. An individual in a hoodie, also not that unusual. But when you take 2 unusual things and put them together, you're now looking for a much more specific thing. You're looking for 2 people that fit descriptions. 1 with a hoodie, 1 without, both with dark
You said
clothing.
2 unusual things, you mean 2 usual things.
2 usual things, but when placed together become quite a bit more unusual.
Did the victim, did he see the 3 run off together? Did he say that?
He did. I believe that's what is relayed by
So,
officer.
as far as we've got witnesses seeing them leave the house, the 3 are together, right?
Correct. Correct. It's during the commission of the breaking and entering where they're kind of operating as 2 separate units.
Okay.
Now, after they leave that area, they're approximately a mile or so away when they're encountered by Officer Anyos. This is a relatively reasonable distance to be over that period
Well,
of time.
let me ask you that, though, because as I thought, when Officer Anyos sees them, it's somewhere 23 to 30 minutes, because he's talked to the people for 8 to 12 minutes, and then he was driving around. It's somewhere in that vicinity, right?
So Officer Anyos testifies 2 separate times. One, he says 15 to 18 minutes is the time. The second time he's asked that question, he says 12 to 15 minutes. So those are the 2 estimates between,
But that's after he's talked to the people for 8 to 12 minutes.
for 8 to 12 minutes.
Yeah, so you have to add them together, right?
No, that's the time from the home where the breaking and entering occurred to the initial encounter. That's his estimate of
8 to 12 minutes?
total time elapsed.
8 to 12 minutes?
He's at the address for 8 to 12 minutes.
Yeah,
He
and-
encounters them 12 to 15 or 15 to 18 minutes later, meaning he encounters them around anywhere between 3 and 10 minutes after he leaves the house, according to his testimony.
Really?
That's, on transcript 17 and 26 are the 2 times he answers that question directly. What is the time from the house, from the call to the first encounter.
Didn't, maybe you're right, because I haven't looked at the transcript, but, I mean, so you probably are right. But didn't Judge Green say that these were two different times? That is, you got the 8 to 12 in the house, and then 12 to 18 out of the house, so you add them up together?
Well, that's because Judge Lyons seems to make it that way. She says that Officer Anjo spoke with the victim and his foster mother for approximately 8 to 12 minutes, and then blah, blah, blah. He sent, during the next 15 minutes, he proceeded to Walnut Street and Martin Luther King Boulevard.
I mean, if you go to the low end of the first estimate, the 8 to 12, and the high end of the second estimate, 15 to 18, you're still talking about that period of time, 10 minutes.
Roughly half an hour.
Well, it's not 10
Between.
minutes, it's,
Half an hour.
10 minutes between leaving the house and encountering them.
So if he's
Oh,
only
15,
out there
no,
for
no,
3 to
right.
4 minutes, how does he canvass the area and doesn't see anybody? I mean, I thought he spent some time canvassing the area, didn't see anybody else out before he got to the park.
I mean, I just, to be clear, with either one of those answers, he leaves the house and is canvassing the area for somewhere between 5 and 10 minutes. And so he's out in that area driving around in his car. I think that's he can cover a substantial.
I think that we're sort of missing one another here. What I hear my colleagues asking you is if you add, it sounds like there was a half an hour between the time that he arrived at the house and started talking to people and the time he first saw the two men. If you read the opinion, what we're gathering is it sounds more like a half an hour than 15 minutes.
So the
Can you clarify that?
The question that Officer Anyos is answering is specifically how long between the call to the time that you first encounter these individuals. And he answers that question on transcript 17, and it's
And that's in the
15
judge's, sort of the motion judge has two different sections where she talks about the timing piece. One seems to be consistent with what Justice Botsford was saying, and the other is where she cites his testimony that he estimated he arrived at the park and Dale, which is where he saw the defendant, 12 to 15 minutes or 15 to 18 minutes after the call came in. So that's what you're looking at, and we're looking at the earlier section where it's 8 to 12 minutes at the home, and then 15 minutes later, he essentially encounters the defendant.
And
So there's
the motion judge in her analysis says within 20 minutes of the incident they encounter these people, which is pretty consistent with the testimony, give or take a couple of minutes.
Now, when he made his radio broadcast, didn't he say he had a visual of 3 males? But at the hearing, he said he observed only 2 males?
He did, and I think that was clarified during the hearing. He was
How
asked.
was it clarified? Was it 2 or 3 that he saw?
It was 2, and he said that he had the opportunity to observe them for upwards of 20 seconds before he lost sight of them in the park. And during that time, he was absolutely sure it was 2. It was just a misstatement based on earlier descriptions.
Now she writes that he saw 2 males wearing dark clothes. I don't see anything about a hoodie.
That's in her factual findings.
In her factual findings.
one of the individuals was wearing a black hoodie.
Sorry, where's that on
She
page?
observed two other black males wearing dark clothes. One of the
No,
individuals
that's
was wearing
that's what the witness to the event said.
Correct.
But on R12, the judge says, the officers responded and observed 2 males matching the description wearing dark clothes.
So in the analysis on R13, about a third of the way down, it says a black male in dark clothes and a hoodie was seen walking with another male in dark clothes. So she kind of makes additional findings in her analysis beyond the factual findings in the first section. And I think this kind of lends itself to the Commonwealth's erroneous findings. I would suggest also a little bit of confusion on when the grabbing of the waistband occurs. There's essentially 6 points in the record where the grabbing of the waistband comes up. 5 of them are unequivocally clear that it happens prior to even the first command to stop. The very final question by the prosecutor is, does the grabbing of the waist, does the touching motion happen prior to the command to stop? The officer says no. That doesn't discount the possibility that it was contemporaneous. And it doesn't certainly disclose the other 5 times when the officer said it happens prior to the command.
Well, he's clarifying at that point. I mean, he's been asked that same question, and now he gets asked directly, does it occur before, before, and he says no. So why isn't that the best answer to the question?
I mean, the other questions were also relatively direct. On cross at one point, he's asked if the defendant is pumping with both arms the minute he starts running. He says no because he's holding his waist. He's then asked when he gives the command to stop. He says shortly into the chase, or additionally saying as he's going up the hill. These are all after he initially starts running, which really kind of goes to the fact that as he's running, he's holding his waist. That's what the officer's testimony
But,
is.
I mean, first of all, I gather you didn't go back to the judge and say, you made a typo here, can you revisit that sentence?
No, and this court certainly has the ability to remand for
Why should we?
for clarification. I'm not even sure it's necessary, because I think even if the stop occurs prior to the grabbing of the waistband, there's abundant reasonable suspicion
Okay,
here.
well,
and
you went through the
officers-
first 2, so I know you've got the one black hoodie, one dark clothes, you have the time from the call, you said you have 7, you've got
The-
5 more to go, and you've
the
got 4 minutes to do it, so.
Yes, Judge. The spatial and temporal proximity, I think, are both reasonable. Within 20 minutes, about a mile away, we have the description. There's now 2 separate times when the individual flees from police. The first time, the officer sitting in his car, lights are off, he's driving slowly down the street and sees them coming at him. He says, "Hey, fellas, wait a minute." They pick up their pace and jog into the park. The flight from the officers plays into the reasonable suspicion determination. At the other side of the park, we have Officer Carr, who barely steps out of his vehicle and only gets "hey fellas" out of his mouth before the defendant flees. I think it's particularly noteworthy that that flight, not only is it the second flight, but it's a little more of an extreme flight than the first time. It's similar to Sykes, in which this court found it instructive that the second time that individual flees, he crashes his bike and leaves the bike behind. It's kind of an extreme flight as opposed to the first time where he just speeds up.
Does it matter, as Mr. Levin suggested, that Officer Carr didn't know about the other fleeing?
I'm not sure that it's clear that Officer Carr didn't know that.
Well, let's just assume for the minute that it does. He didn't. Does that matter, or do we take all the police knowledge together?
I think the officer rule is essentially that they have a collective knowledge of what's going on in the situation. The record reflects that Officer Anyos relayed to Officer Carr his observations of these people. It's not specific as to exactly the language that he used and exactly what he relayed, but I think that statement attributes Officer Anyos's knowledge to
Didn't he,
Officer Carr.
I thought he put something over the broadcast.
He did. He says, "I gave a description of the people that I observed going through the park," and Officer Carr picks them up at the other side of the park.
But I mean, how much weight can we give to flight? They are free to leave. The stop, you say, did not occur when you said, "Hey, fellas," correct?
Correct.
So they're free to leave, so they exercise their right to leave. So how much weight can we give to the fact that they exercised their right to leave when they were free to leave?
And certainly, flight alone does not make reasonable suspicion, but we now have 2 instances of flight, one more extreme than the other. They quicken the pace the first time and start jogging. The second time, the defendant actually leaves his friend behind and takes off running. I would suggest that's kind of informative of the lengths he's willing to go to flee the police, where one of the 2 individuals stays put and the other one flees. That should tell the officers a little more about the fleeing individual.
Okay, so
are the rest?
you got proximity, you got time, so you got a description, you've got time, you got flight, you got 4 others, and you got a minute and a half.
I count both of the flights separately. I would count
Oh,
time
that's
and
3 and
proximity
4, okay. You got
separately.
Then you have 3 left.
I'd also ask that the court consider the severity of this crime. So it's clear in the case law that where officers are investigating something like a shooting, that can play into the reasonable suspicion determination, the need to make quick calls and the public safety
There was
interest
no
there.
word about a gun.
There was not.
The B&E,
That's
but
correct.
there was nothing reported by anyone at that point.
That's correct. But what we have here is
So how is this such a severe crime?
what we have here is a breaking and entering in a residential neighborhood at a time of the evening when residents are almost guaranteed to be in their houses. I think you can draw the inference there that anybody breaking into a house is expecting or is aware of the possibility of a confrontation with the residents of those houses. It's a particularly bold thing to break into somebody's house knowing that they're going to be home or that there's a great possibility that they're going to be home.
Any more?
And your last two?
So I count those as
got
all
five.
of them.
I got five.
Reliable known witness, the description, location, time, two instances of flight, and the severity of the crime. I would just briefly note, recently the court made the decision of Jones-Pinnell in which it's actually the same officer, and the language in that case was heavily scrutinized as him calling out, "Wait a minute." That case is distinguishable in that it's clear in there that the officer said it in a loud voice. That was the motion judge's finding, that it was in a loud voice and that he yelled it. That's quite a bit different than this case where it's coming from the motor vehicle and the officer is just asking them to wait.
Okay, thank you.
Thank you.